essence found that it was either transmuted or in some way commingled, or it was used by the parties as marital property. And we find a problem with that in two ways. Number one, there was not a factual basis related to things that we thought in our mind came to a transmutation or commingling. And that kind of is driven, as I know and the court knows, by factual matters. In drawing your attention, I would draw your attention to our brief where we have outlined this. My client, who is the husband, purchased this property before the parties were married. He had a contract to purchase it. It actually closed after they were married, but in association with the contract to purchase it, he paid $65,000 before the parties were married. Subsequently, there was a deed given. It was in his name solely, and there was a promissory note that he paid, and it was in his name solely. Subsequent to that, it was refinanced, as people will do when they find a better rate or something else happens. And every time that this property was refinanced or anything was done with regards to the property, it was maintained in my client's sole name. The court seemed to focus in upon the fact that the wife signed a deed of trust. As the court is aware, having bumped into property matters, I know, you can claim that there's some sort of a marital interest against a lender. So the lenders always get a deed of trust from everyone. That's not in our mind dispositive, because that was nothing that my client did. That was something that the lenders did. We would like you to sign a deed of trust because we want to protect our position. My client, and this is, I think, the salient and important fact, never undertook any action to commingle or transmute this property from a separate property into a property that the wife could
Was it paid for with marital funds?
To an extent, it was, because he worked, she worked, and they maintained totally separate assets and accounts. If Your Honor looks at the record, and we brought that issue out before the court, these parties never had a joint checking account or account other than when the wife started a business and the bank requested that my client sign on that checking account because she didn't have significant history.
Wasn't the wife here, though, a homemaker for an extended period of time, taking care of the couple's child and so he's working, it's money that he's making at work that they're using, but she's at home as a homemaker taking care of their child and enabling him essentially to work like that.
That is true. There's some of that, but the question really becomes, under the statute and under the case law, is that a significant and real contribution to the increase in the value of the property?
This house was also remodeled multiple times, right? I mean, there's multiple projects going on inside the house, the kitchen, the whatever, over the years, or am I wrong about that?
My recollection is they repainted and did some work in the kitchen. My client, I think, installed a swimming pool, but that was something he did, and I don't remember the timing on that.
Did the wife oversee those projects that were when the kitchen's being remodeled, or the?
I think what she said is she picked colors. My client picked the person who did the work. My client is a contractor. He is a contractor, so he was the person who drove that. My client directed the construction. Respectfully, the wife, who's a nice, competent person, sells clothing and has a nice store in Dixon, Tennessee, where she also does some medical things. But my client actually was the person who was the contractor, drove all that, and did all the work. And as a result, I would respectfully disagree with that characterization because of the fact that my client was the contractor. The salient facts, we think, are that her testimony, and I've reflected it in the brief, was, I was his wife, that's my claim.
Let me ask you.
Yes, sir.
When the land contract was executed in 2008, did title to the property pass?
It did not at that point.
And when did it pass?
It passed shortly after, sometime after they were married.
And so we're talking about property acquired during the marriage then?
It is, but if Your Honor looks at the statute that outlines what is marital property versus marital property, it makes reference to property, but it also makes reference to property rights. This was clearly a property right that my client acquired before the parties were married. It is a property right that my client paid $65,000 to own before the parties were married. And as a result, we think it maintains a separate.
So under the definition of marital property in the statute, doesn't it specifically say that any property acquired during the marriage is marital property, such that the trial court really had no reason to even consider transmutation and what the party's intent was in regard to that property?
Well, again, I would refer the court to the statute, and I've got it written down here somewhere. The statute says that property, marital property and separate property includes things that are owned or property rights. And the statute also makes clear, for example, if you own a McDonald's before you are married, and it's just the franchise right, and you sell that franchise right and use that money to buy a Wendy's franchise, the characterization of that money does not change. It remains a separate property, and that is something that we believe is recognized by the statute and intended by the legislature. So even if you have a property right, if you transfer that property right after the marriage, but you maintain the separate nature of the property, it remains separate property. So I don't know if that answers your question.
Well, I don't know that it satisfies my question, but I understand your argument.
Okay, very good. Now, there's also a couple other things that I wanted to bring up, and those had to do with trial court matters that were presented. Number one, there was a Rule 1006 summary that we submitted. What we did was trying to get a hold of this lady's income, actual income, was difficult because, as I said, these parties maintained separate lives. She had a business that my client was not involved with, although he helped finance. He had several businesses that she was not involved with. We came up with all kinds of different numbers for her income. What we did, and this is kind of standard practice, we got financial statements and things she submitted when she wanted to get a loan. And she would claim she was making $10,000 a month. She would claim she was making $5,000 a month. And then miraculously, she was making a lot less. We looked at her accounts, bank account statements. We did that and put together a Rule 1006 summary that outlined just things out of her business account that were spent, like at Kroger, at Walgreens, at Wendy's, and I don't know if it was Wendy's or Sonic or whatever, but all of those things, we identified that. We thought that was fair game, and the court said, well, you can't tell us what every one of those expenses were for. In other words, you can't tell me if that expense was for business or not for business. That's absolutely true, but that's really not the basis of a summary. The basis of a summary is, can you identify something from admissible evidence that identifies specifically the expenditures that you're talking about? And that is, in fact, what we did. So that we think the summary should have been admitted, and I'm about out of time, so I'll just run on. Alimony was awarded. We felt that it was inappropriate for the reasons we've set forth in our brief. She came to the matter with unclean hands. We also have a criminal contempt that was initiated against my client. We don't believe that the evidence was sufficient to find that. In other words, there was no proof as to times and things sufficient, we thought. Attorney's fees was important also. A very large attorney fee award was made in this case. Respectfully, under the Rule 1.5, there were no specific findings that were made, and we didn't think the court took into account everything they should have. The other side would bring 3 attorneys to every hearing. We would bring 1. And I'm over.
Let me ask you in regard to the
Sure.
attorney fee.
Yes, sir.
Is that a stated issue on appeal?
It is.
And you certain about that? That you included that as an
I
issue?
believe there's a
in your
reference
brief?
to it. Yes, sir. On the table of contents on page 5, or we identify it as section 5, and on page 49 of the brief, facts related to the award of attorney's fees show they were excessive.
So you've got it in your table of contents, you argue about it in your brief, but you don't state it as an issue? Is that what you're telling me?
I don't know exactly.
There's a section, statement of issues. Is it in that section?
Go forward here. No, it was not, but it is listed there as an issue.
You said no, not listed.
There's one section where it says issues, and then we also have a section that lists it as something that we argued about, so.
Okay.
Thank you.
Good morning.
Good morning.
I'm Roger Manus. I represent, along with my colleague, Colleen Hyder, who's with me today, who labored alongside me in this vineyard for the last 3 years. We represent the wife, Laura Michael Hudson, in this matter. What I would like to do today is first and foremost address any concerns that you may have regarding the issues that were briefed on the matter. The question to Judge Armstrong's question was, yes, it is marital property because it was acquired after the marriage, and it was not identified as an issue. The attorney's fees was not, and the issues presented for review, but it was briefed, and so I addressed it in my brief. Those are the direct answers to the court's questions in regard to that. Now, back in the late 70s, when I attended what was then Memphis State University Law School, Professor Garrett taught me that in domestic relations, that when man and woman married and became husband and wife, they became one at common law, and the one was the husband. Well, that's not been the law in Tennessee. Divorce law in Tennessee is statutory and has always been, at least for the duration of my career. And that's not been the law in Tennessee at least for the 44 years I practiced law. The statute is very clear in terms of how, and it's been expanded over the years in terms of how we determine what is marital property, what is not marital property, what's separate property, and what can become marital property by virtue of transmutation and otherwise. In this case, the court classified this property, this home, as marital property, and the rest of the story is that the parties were dating in 2007. My client became pregnant with a party's child in early 2008. They began to look for a marital home together. And in April of 2008, they found this home at 117 Highway 149 in Cumberland City and determined that they would purchase it as a marital home. Not altogether different from what occurs in a lot of families. The husband made the arrangements for it. He was the primary wage earner at the time, and he set the deal up in his name only, in a what I would call a land contract.
Counsel, was the $65,000 that's referenced by opposing counsel paid before this couple was married? Was that fund, were those funds transferred before the actual marriage?
I don't know the answer. I don't know that that's in the record in terms of when that money was paid. I'm fairly certain that it was paid before the deed to the property was received in 2011. But that would have been long after the parties were married. So, Your Honor, I don't know. Frankly, I don't think that's in the record in terms of when that actual payment was made on it. So the court then examined the respective relationships of the parties and determined that my client's role as a homemaker and parent was significant. And the statute mandates, I believe, under those circumstances, that be given the same weight in evaluating the contribution to the acquisition of property as the role of the wage earner, in this case, Mr. Hudson. So what we have essentially is a situation, and counsel didn't really address this in his brief nor in his argument, but the argument essentially is that my client should go hence and take nothing, because all of the other marital property that was acquired was awarded to the husband. The reason for that, and I'm not sure it was briefed, but it was certainly briefed in the trial court, was this. Mr. Hudson is a bail bondsman. And because he's a bail bondsman, the bail bonding authority is secured in part by real estate. So this property would be acquired during the marriage, making it marital property, and then would be pledged to the state of Tennessee to secure bail bonding authority. So the trial court was somewhat handcuffed in its ability, because of that, to equitably divide or distribute those properties. And so the court came up with a solution, if you will, and awarded my client the marital residence, which had, according to the numbers that were introduced by stipulation or by agreement, had an equity of about $500,000. And that was more or less half of the net marital estate, assuming that the court found that the husband's business interests, H&H Construction, was separate property, which the court did. That case, that classification, frankly, could have gone either way. The proof was that at the time of the husband's drug addiction in late 2008 and 2009, and hospitalization for that, the construction business was closed down. It was shut down. It was completely inactive. And then it was reactivated later during the marriage, and this company H&H, of which he had a 50% interest, was incorporated and organized as late as 2018 or 2019, well into the marriage. So the court could have found that to be a marital asset which would have affected the marital net worth of the marital net worth estate, but the court found that to be separate property. Frankly, I believe that the outcome that the court came up with was within the acceptable range of outcomes, so that it would not be considered an abuse of discretion, and we determined not to appeal. But the crux of the argument that Mr. Hudson makes in this case is we should get the house as separate property and everything else, and Ms. Hudson should get a business that had a net worth at the time of trial of negative $18,000.
Let me ask you about that business. The trial judge was pretty candid in terms of their real challenges assessing the valuation of the wife's business in this case. Why wasn't it error to, or why didn't the trial judge go awry, I should say, with regard to declining to consider the summaries? And wasn't that error?
No, it was not. It wasn't error for two reasons. Counsel tried to put that in during the cross-examination of my client and was unable to lay a foundation. That sort of thing requires a foundation to be laid, and you can't just hand it in. So you have to prove it up through a witness. And so the court told Mr. Olson that you can try to put it in through your client. I'm not sure you'll be able to. Well, no effort was made to do that. No effort was made to put those summaries in through Mr. Hudson's testimony to lay a foundation for the introduction of those summaries, and no offer of proof was made. So what you have is a situation where my client is shown the document, she didn't prepare it, she hasn't had a chance to examine it and go over it line by line in advance of anything. He couldn't lay a foundation through her, and so at that point he abandoned any efforts to introduce this exhibit. It's just not in the record anywhere.
Was there any attempt to admit the summaries under husband while he was on the stand?
No. No effort made, no offer of proof in that regard. So, looks like I have a few minutes left. What I would like to, one matter that was, I really don't care to address the contempt finding unless the court, any member of the court has any questions about that. I believe the proof was overwhelming. It was really undisputed. Mr. Hudson introduced various women into the home in the presence of the kids in direct violation of the order, was warned in open court against continuing to do that, and continued to do it with impunity.
In this case, with regard to the contempt finding, in the end, there's only one count of contempt the trial court finds, right, with regard to the overnight, the paramour being present.
Correct.
And there is, if I recall correctly, there is one specific date, time period where there is a finding essentially that the husband, the paramour, was there on that particular weekend. Am I recalling the record correctly on that point?
I don't think so. Okay. I don't believe so. The trial court, I believe, found that Mr. Hudson exposed the children to the paramour on numerous occasions, and actually the trial court found that Mr. Hudson just didn't care about its orders, seemed not to care at all about complying with its orders in that regard.
In regard to the contempt, did Mr. Hudson testify? And if so, what was his testimony about having this lady present overnight with the kids?
Well, he sort of blamed it on the stepson, interestingly. He testified, he acknowledged and admitted that first Miss Allie Epps was there. Now, he said she was not a girlfriend, but she was there. The order didn't have to be a girlfriend. It just had to be someone who was not prior known to the children. She spent the night there virtually every week. Then he took up a relationship sometime in 2022 with Miss Robin Ross, who had 4 children of her own, and he acknowledged that Miss Ross came and spent the night in the house about weekly on it. That after he had been admonished by the trial court in open court not to do that anymore, he would be found in contempt. He made an effort, he said, to discontinue it, but it became, because of the stepson being there, it became inconvenient, and so the admonition was only followed in the breach after that, and she continued to come with the 4 children and stay in the house. That was Mr. Hudson's testimony.
Let me ask you, what about Mr. Olson's argument that execution of the land contract, which is really not that popular in Tennessee, you see it a lot in northern states. He said by executing the land contract, Mr. Hudson obtained an equitable interest in property, and that the later transfer of the title after the marriage wouldn't make it marital property. What do you say about that argument?
Well, I think it's one of those situations where the trial court had to look at the entirety of the evidence on it. That's what I would consider to be a highly technical argument. The statute doesn't really address, the statute's very clear that it doesn't matter how it's titled, in whose name it's titled. But what the statute says is acquired during the marriage. And so the acquisition of the property, a land contract really doesn't, I know this because I had to deal with it yesterday on a much smaller scale. You don't really get anything until you're in a position to close the transaction and get a deed. You have what's called, I guess, an inchoate right to if you do everything you're supposed to do to buy the property later, to purchase it later.
But it doesn't pass title.
Does not. So, and I think counsel acknowledged that. So, I'd like to address one other thing that may be of concern. It was a concern to me, frankly. And not for the reasons that the court may think. It was of concern to me about the question of the attorney's fees. But again, what I want to urge this court to do is take a look at the big picture in this matter. As a result of the strategy adopted by the husband in this case, we think it was a willful, settled intent to starve my client out on it. She incurred quite a bit of fees that would not necessarily have been otherwise incurred attempting to obtain compliance with the court's orders in that regard. And so at the time the court made its decision, it was an award of just under 60% of the total fees incurred. And in volume 35, we filed our trial briefs, and in reliance on what the court told us to do, we reported the amount of fees incurred and the amount that had been paid. And so my trial brief, signed by me in the matter, reflects that at that point in time, I was owed a substantial amount of money that I had advanced on behalf of the client. And so what we had was a situation where my client had a lawyer who was willing to advance the fees. The court awarded 60% of the total of those fees, and the total amount was made excessive by the tactics and strategy adopted by the husband in this matter. So I think I used up all of my time. So.
Okay. Thank you.
Thank you.
Just briefly, I'm going to touch on some of the things. Judge, you asked whether or not the $65,000 was paid beforehand and whether that was in the record. It is clearly in the record. I would reference, I believe it was Trial Exhibit 12 from my memory. What we did with regards to this property is we put together a compendium of all of the documents that were related to the real property. That included the agreement to purchase property, the deeds and things associated with that. My client testified that he paid all of the payments that were required under the agreement related to the property. And when I asked Miss Hudson if she did anything at all, she said no. And that's paraphrasing her, but no, I didn't do anything. But Exhibit 12, and counsel is aware of this, Exhibit 12 outlines specifically what took place and the times and the deadlines and everything associated with it. So that's where we are. Judge Armstrong, I do want to once again revisit 36-4-121. The separate property makes reference to real and personal property owned by parties. Personal property would include the agreement of property. It would include a franchise for Wendy's. It would include things that are perhaps not closed upon, but a property right. In other words, if my client had sold that agreement before there was a closing, the question would become, would that property be something that was separate property? And it would. And it would be because that property right, that contract, which is again contained in Exhibit 12, that is something that my client owned and paid significantly for, $65,000, before these parties were married. So so
you're looking at the definition of separate property,
yes,
to characterize this property, which was acquired during the marriage. Why wouldn't you look at the definition of what is marital property to make a determination about whether this is marital property or not?
because the separate property at Section 4B says property acquired in exchange for property acquired during the marriage. In other words, if we acquire this property right, in other words, I have the Wendy's franchise and I sell it and use that money to buy the McDonald's franchise, that does not lose its characterization as separate property. Just as in this case, the agreement that he had, that he paid for, that she paid nothing for, maintains its position as a separate property right. I think there's absolutely no argument that can be made that says that that agreement that he made to purchase that property before is separate property. I cannot think of a way that under the factual matters submitted in this case that that could not be separate property. If,
You don't dispute that title did not pass at the time of execution of the land contract?
absolutely do not dispute that. But in terms of right to the title, it certainly was acquired before these parties were married. In other words, before they were married, he acquired the right to the property. He acquired the right to purchase the property. He had a right to that property that if they had tried to go and sell it to another party, he could go to court and assert. This is a real live property right I have right here. See, we all signed this contract. So in my estimation and my thought process, that is something that would be property acquired in exchange for property acquired before the marriage. In other words, I'm taking my agreement and I'm executing upon it. So there we have. And the council made a few other comments that I'd like to make reference to. Council has, with regards to the contempt, and I'm going to hit that just briefly. My client engaged a person named Allie Epps who provided services for his sick mother. My client also dated another person. Part of what the problem is, and it's my recollection from the record, there was one time when these parties were really, really together, and it was when they went to see the Ark with a church group in Kentucky. Now, were there other things going on? Absolutely. Mrs. Hudson had a boyfriend that she was spending significant time with, but that's what happened in this case. In other words, in terms of, with regards to, I do want to touch base on the summary. We complied with everything we were required to do. Summary 1006 requires you to give the documents to the other side. We did. Requires you to give the summary to the other side. We did. We then summarized for the other side, this is what these documents say. And when they say that in some fashion they didn't know what they were her bank account records that we subpoenaed. And when we got those bank account records, we went through and we could see what had happened. And respectfully, we laid a foundation for that. The documents were subpoenaed. The documents were properly before the court. The documents reflected accurately things that were reflected in those documents, and they should have been admitted. So unless you all have questions, that would conclude.
No questions.
Thank you all very much.
Thank you both. Would you call the next case, please?
Janine Halterman.